Hello, good evening, or good morning, depending on when you're seeing this video. All right, so I'm going to be going over the defense response to the state's notice of intent not to cross-examine witnesses, and by that they're talking about Miss Vargas and Miss Larkin. So let's take a look at this, and you tell me what you think. I really thought that the state had a really good point when I read their notice not to cross-examine, but now I read this and I'm not so sure. They have some really good points too. So I'm going to go over it with you right now. This court conducted a hearing on August 18th, 2023 on Mr. Kohberger's third motion to compel. 4 witnesses testified for the defense, and the state reserved the right to cross-examine 2 witnesses. That was when Stephen Mercer, Leah Larkin, and Gabriela Vargas, and a couple others testified that day. That was that hearing that she's referring to here. On August 30th, the state filed notice that it does not intend to reopen the hearing and cross-examine the 2 witnesses. The 2 witnesses being Miss Vargas and Miss Larkin. Referenced in the state's notice of intent not to cross-examine defense witnesses are a 3rd District Court transcript from CR 14-20-07840. Mr. Don't you love it when you do that? Mr. Kohberger's defense team has reviewed the exhibit and provides the following response. At first blush, it appears the issue before Judge Whitney in State versus Dalrymple was that the state was seeking a protective order relating to a database that produced information leading to Mr. Dalrymple's arrest. However, the decision Judge Whitney announced was on a different issue and was made without the benefit of expert testimony relating to the forensic IgG process. It is noteworthy that even without the benefit of that testimony, Judge Whitney concluded that the state needed to turn over in discovery everything in its possession relating to genetic genealogy, and the defense was welcome to bring further motion on the issue. This court is asked to decide something different. The information sought by Mr. Kohberger through his motion to compel is the same information that the state seeks to protect with its motion for protective order, which is the SNP profile created on behalf of the state and the genetic genealogy process directly used by the state to identify Mr. Kohberger. Mr. Kohberger is not asking for a genetic genealogy database. Rather, the analysis and documentation utilized to identify him. Mr. Kohberger has also asked for the SNP profile, and the state has agreed to provide it. This court is left to decide whether to shield the analysis and documentation developed and used to identify Mr. Kohberger, or to order it be provided for his defense. Lastly, this court has knowledge of the intricacies and prohibited law enforcement access to various DNA databases. In Mr. Kohberger's case, the Latah County prosecutor, the Moscow Police Department, and the Idaho State Police and the FBI worked together to investigate the case and identify a suspect. At some point, genetic genealogy was utilized for identification. That information remains withheld from Mr. Kohberger. Mr. Kohberger does not even know when this began or when he was supposedly identified. That policy requires that all forensic genetic genealogy profiles, account information, and data shall be retained by the investigative agency for potential use during prosecution and subsequent judicial proceedings. There is a relationship between a local, state, and the federal government to work together. DOJ policy requires retention of analysis and materials for use in judicial proceedings. This knowledge, in addition to the potential for misuse of information, is something that is discoverable and necessary to Mr. Kohberger. The investigation related to the car includes hundreds of names of individuals owning a white Elantra. The evidence held regarding DNA is no different. The court in Dalrymple incorrectly permitted the state to hide material from the defense by claiming they did not have it. That is not how discovery works when the state decides to work with outside agencies to take liberty from someone. This court has thus far shown that the FBI does not exist outside the discovery rules. It should not grant them immunity now. Conclusion: the transcript provided from Judge Whitney does little to instruct this court about what should be decided. This court has a different question. Mr. Kohberger requests materials and analysis, not a database. These materials are required by the DOJ to be retained for use in judicial proceedings. This court has the benefit of understanding the process and the materials that were created in this identification of Mr. Kohberger by the state and its agents. Mr. Kohberger respectfully requests the court order the state to disclose the materials. Mr. Kohberger is happy to comply with any limiting order the court deems appropriate. All right, let's go down here and see what we have under exhibits. I have read these on the website, so I know what link it is, and I'll post it in the description. It's pretty interesting stuff if you like reading. That is it. Okay. All right, so again, there is a hearing in 7 days for the defense's motion to remove cameras. The media has entered the ring. They're ready to fight. I don't know the state's true position on this. They haven't responded to that yet, but I suspect they may be okay with probably whatever the judge orders, but I think they're probably okay with cameras. I don't know why the defense wants them out. Again, I think cameras should be there. They should just be fixed to one corner or something where they're focused just on the judge and the witness stand. That's really all we need to see. If we can get a shot of him coming in and a shot of him leaving maybe, and then from then on only focus on the judge and the witness stand, I'm cool. I'm fine with that. I'm even okay with, if they're not going to live stream it, if we can just see it later in the evening at the end of each day, I'm fine with that too. Don't like it, but I would deal with that. But if they just remove cameras, that's not good. It's really not good. So what do you think about that? What do you think about this response that they filed? It's really interesting. And they did make some good points. This is why they're lawyers. This is why they make the big bucks. That is it for this video. Thank you so much for watching. Be sure to hit the like button for me. I really appreciate you. I have another video that I'm working on now that should be up in the morning or later today, depending on when you're seeing this video. Have a great night or a great day. Thanks. Bye.